Good morning to all of you. In the law of torts, particularly medical negligence, Bolam test, Bolam rule, Bolam case is very, very important. So, just like the principle of profession dash occupation in the IMEA versus BP Shanta case 1995, or where you cannot file the consumer case if it is a charitable hospital, and Jacob Matthew versus State of Punjab 2005, where it is held that negligence, medical negligence, can only be confirmed by examining or taking the opinion of medical officer. Now, Bolam test is also very, very important because medical negligence is very difficult to be established. Ordinary people, they do not know how to prove a medical negligence. That too, there is an Indian Medical Council, IMA, Indian Medical Association. They are there to decide or to protect the interest of the advocates, to eliminate or to take action to punish the black sheep in this. But anyway, according to the Consumer Protection Act, presently 2019, the service rendered by the corporate hospitals or the hospitals which collect the fee, it is also service. So definitely, if there is any deficient service, the patient can file a case of consumer protection, right? Now, we are going to discuss the Bolam test. So, these are all the concepts which you have to remember. It happened in the year, I think, 1957. So, this is, you can read the case as Bolam versus Feiern, F-R-I-E-R-N, Hospital Management Committee, right? So, here what happened is, Bolam is a voluntary patient, in the so-called Feiern Hospital Management. So this is a mental hospital, to be frank, directly say, it is a mental hospital. This man has having a lucid intervals, appudu pitch vastundi. But anyway, he has gone there, he wanted to treatment, he voluntarily got admitted, right? Okay. Now, he wanted to undergo the electroconvulsive therapy. Appudu pitch vada current kuda vasina paristhiti vastundi. He wanted to undergo. So at that time, so he has undergone that, but he received injuries during the therapy, and he filed a case against the hospital management on 3 grounds. Number 1, not issuing relaxants. So muscles current pedite, they get contracted, is it not? Getti pedipothayi. Even man BP chusukodanike maavida control getti pedipothayi. Even mana paristhiti kuda ante anukondi. So the relaxant, muscle relaxant, లేకపోతే ఏమవుతాయి, కాంట్రాక్షన్ వస్తాయి, కంట్రోల్ పెట్టేసి చాలా ఇబ్బంది వస్తాయి. ది సెకండ్ పాయింట్, నాట్ రిస్ట్రైనింగ్ హిమ్. సో అతన్ని మామూలుగా బెడ్ మీద కట్టేసి మనకు తాళతో కట్టి ఉండి, కాళ్ళు కానీ ఏదో ఒకటి కట్టి ఉండాల్సింది, కట్టేయకుండా ఫ్రీగా వదిలిపెట్టారు. థర్డ్, నాట్ వార్నింగ్ హిమ్ అబౌట్ ద రిస్క్ ఇన్వాల్వ్డ్. ఏమయ్యా, ఈ కన్వల్సివ్ థెరపీ వల్ల నీకు ఇబ్బంది ఉంది, సపోజ్ ఏమంటారు దిస్ కార్సినోమా ఆర్ cancer. Cancer patients, they need radiation treatment. So at the time of radiation treatment, due to the heat, all the hairs will be up. All the hairs will go away. So they have to inform him in advance. So this was not done. So Bolam test, 3 points. Number 1, not giving the relaxants, not informing him about the consequences, and not restraining him by not tying him. Now, what is the medical opinion? This is more important. So when they refer to the medical opinion said, please remember, Justice McNair, he took the medical opinion. It was noted that use of relaxants, medical opinion is totally against it. There is no necessity for the use of relaxants. Suppose if you use the relaxants, you will be free. So the condition, the person should feel the so-called heat. And second, there is no practice to warn the patients. Suppose if you warn the patient, he may not undergo the so-called electroconvulsive therapy. That problem is also there. There is no necessity to inform him also. So this practice is relating to the standard of care. So what is negligence? Breach of duty of care. That to standard of care. So when you did not inform him about the consequences, it is not breach of duty of care or standard of care. When you did not give the relaxants, it is also not against them. So therefore, the court held that there is no negligence on the part of the hospital. So please remember, the medical officers, they are not guilty of negligence. Please remember. So that's why actually if the doctor practiced as per the accepted principles of the so-called standard of care, then even though the patient files a case of the so-called negligence, it will not be accepted. Please remember, this has to be accepted by the body of medical officers. So in this connection, the principle laid down in the Bolam test rule is 4 Ds, D4 or 4 Ds. So what are they? Number 1, duty of care. Negligence is nothing but breach of duty of care. Duty, the doctor has a duty to take care of the patient, to admit, so he has a duty. Whether he exhibited requisite skill in his duty, whether he has exhibited requisite, whether he has got skill and whether the exercise is the same or not, it is a question, that is in duty. Second is dereliction or deviation from the standard of care. How the dereliction happens? Deviation itself is negligence. How? Suppose a patient has come to the hospital. They wanted to conduct the operation, but the anesthetist is not available or the oxygen is not available. In that cases also, if you are ready to go for the surgery, if you are ready to conduct the surgery, is nothing but negligence. So this is important. Third one, damages. Of course, that already I told you, breach of duty of care should result in a legal injury. So that legal injury in the shape of damage, you will claim the compensation in the shape of compensation damage. And last point is direct cause. Please remember, so normally if you conduct the operation, if it fails, if it dies, of course we cannot give assurance that every operation will be successful. So if you do it in a negligent way, if the damage is directly connected to your action, yes, definitely you can feel that it is negligence. But if it is not direct, there may be some concurrent effects. Suppose మీరు ఇక్కడ ఆపరేషన్ చేశారు, అది ఎక్కడో ఇంకా వేరే ప్రాబ్లం ఉండి దాని తగిలి మనిషి చచ్చిపోయాడు అనుకోండి, you need not be held responsible. That is what is called direct cause. So associated causes ఉంటాయి. ఎందుకంటే ఒక మనిషికి ఆపరేషన్ చేసిన తర్వాత ఒకసారి కాలు తీసేస్తారు, కాలు తీసేసిన తర్వాత నెక్స్ట్ లోపల సెప్సిస్ రావచ్చు, గ్యాంగ్రీన్ రావచ్చు, ఇంకో పార్ట్కి ఎఫెక్ట్ కావచ్చు, అతను చచ్చిపోవచ్చు. దానికి ఇతని డైరెక్ట్ కాజ్గా రెస్పాన్సిబిలిటీ పెట్టాలి. సో దీస్ D4, that is duty, deviation from duty, damages and direct cause. These are the important principles in the Bolam test rule. Bolam, please remember, Bolam versus Feiern Hospital Management Committee 1957. So this is an important case where 4 Ds principle has been coined. So if you know this much, it is sufficient, right? Thank you very much.